Well, I know there's nothing there that they don't know.
Did you see the offer?
Before a single plea is entered, this courtroom is already heavy with tension. A third-degree felony, an allegation involving a pregnant victim, a judge who wastes no time making the stakes crystal clear. What you're about to witness isn't just a routine hearing. It's a sharp reminder of how fast lives can change inside a courtroom. Watch closely, because this case takes unexpected turns, strict warnings, moral judgments, legal maneuvering, and a deal that could mean freedom or jail, depending on one wrong move. Stay with us. The details matter here.
It's a crime. People commit that crime. And it carries with it up to 10 years in prison. The person who is the victim here, who is this?
That's the mother of my children.
Mhm. Do you understand you cannot have any contact with this person?
Yes, Your Honor.
You do, you will be in jail. It'll be so fast. If I find out you've contacted her or someone on your behalf contacted her until we can resolve this, you will sit in jail.
This is where the gravity of the case fully lands. The judge isn't just reading allegations. He's framing them morally and legally. Assault involving a pregnant victim immediately elevates the seriousness, which is why this charge carries up to 10 years in prison. The warning about no contact isn't casual either. Violating that order wouldn't be a slap on the wrist. It would mean immediate jail time. Notice how the court emphasizes control and prevention here. Let me ask you, do these firm boundaries protect victims, or do they already signal how little tolerance the court has left?
Altercation, he began to assault her. During the assault, Scott forcibly placed his hand on her throat, impeding her breathing. The victim wished to file charges, and she had visible injury to her body. I believe and do believe that Scott intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the victim by applying pressure to her throat to prevent further acts of family violence. I place him under arrest. And he was transported to the Jefferson County Jail. Well, that's a terrible set of allegations. Okay, so it alleges that you intentionally, knowingly, and recklessly caused bodily injury to the victim who was pregnant, and you knew that at the time of the offense. You would know, since she's your girlfriend. I guess that's your child.
Yes, Your Honor.
And you committed the offense of choking her and pulling her hair. And then it ends, like all indictments, against the peace and dignity of the state, signed by the grand jury foreperson. Okay, have you talked to the victim?
I have not, Judge.
I want to know if he has any contact with her. I want
Okay,
to know that
sir.
because it would, if you call me at midnight, we'll get everybody together in court here at 2 a.m. and deal with this quickly.
Yes, sir.
But I
Charlton.
don't want this person being influenced illegally. What are you going to do today?
Set for trial, Your Honor. I've talked to my client several times, and we want to.
Have you talked to the victim at all?
There was a note,
You didn't
Judge,
talk?
that the prosecutor before me had already talked to her, and
Why
I
don't you do that?
Yes, sir.
I've done this long enough. I'm sensing a whiff in the wind. All right, it'll be set for trial. So today, it says other hearing.
No,
What
it's
does
not.
that mean?
No, it's no other hearing. I had reached agreement with Daniel to refile this as a misdemeanor. And Daniel did talk to the.
What is it? What are you filing? What was it going to be?
It's to allow a plea to misdemeanor assault, which doesn't require a refile judge.
Yeah, we
Because
can
of
do
the
it
nature
here.
of this offense, it
I
could
think
be done.
it's a lesser included class A, probably.
We talked
Yes, sir.
about recalls, what I talked to Daniel about.
I'd rather do it here. I mean,
Let
get it
me
done.
double check the elements here, Judge.
It's an
Because,
aggravated, commit the felony aggravated assault.
yeah, we can certainly do it as a
So
lesser
assault,
included offense.
lesser included class A misdemeanor.
Yes, sir.
But then that would put her on a felony,
What?
like community service and like misdemeanor community service.
I don't know.
You know,
What they
we
do.
that's like 60 hours. I don't want to have a felony time. That's why I was going to refile it as a
Wait a
misdemeanor.
minute.
Not
Wait.
time, but you know what I mean.
That's
That's what's a
right.
condition.
It's clear that these notes say that the agreement is to do a class A misdemeanor assault, 2 years deferred, no fine. And not to
Well,
argue with
okay,
Mr.
yeah.
Adams,
Yes.
this can be done with as a lesser included
Yeah.
offense.
Let me, the probation office, is there a difference between what they do in misdemeanor versus in felony on what? Community service?
Yeah, because normally misdemeanor.
Hold on.
I'm sorry.
But on community service, but if it's a misdemeanor, wouldn't we treat it as a misdemeanor? It would be treated just as it would be a misdemeanor. And if you have a problem with it, let me know, and we'll modify it.
Well, then if you wouldn't mind, just because normally in misdemeanor court and Mr. Ham used to.
I'd rather I'd rather keep it here.
The community service,
It here.
that's fine, but the community service is normally like 40 to 60 hours.
Once again-
I don't want to get hit with
once
200
again,
hours of
I know.
felony stuff.
Once again, I reduce.
It's 80.
This is the moment where legal strategy takes center stage. What began as a felony case quietly pivots toward a lesser included misdemeanor, and that shift is massive. A felony conviction follows someone for life. A deferred misdemeanor offers a path out, but only with strict compliance. Listen carefully to the judge's tone here. He's skeptical, methodical, and very aware of precedent. Even community service becomes a debated issue. So here's the real question. Is this justice being balanced carefully, or is this the system negotiating consequences behind closed doors?
I'm an internship. I don't know why it would be. This is the first time I've done this for 20 years. This is the first time I've heard when we reduce it, it's treated like it's a felony versus what would normally be a misdemeanor. I've never heard that. Really, I wouldn't have. I would have thought that's odd. I would have said something, but I've not heard that. And she's saying that's not the way it is.
So you good?
Okay. Then
All
let's
right,
do it.
let's
Let's
see.
move. Thank you. David Kelvis.
I believe they saying he was in federal custody.
All right, we are ready to proceed with some matters here before we go into the trial. We call 25 CR 478, the state of Texas versus Kirsten. Is it Kirsten?
Yes.
Actually, it's Kirsten Torrey. One of your parents' surnames, is it Torrey? Is that a familial name? Torrey? Is that where it came from? And you were here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 2nd, 2025 in Jefferson County, Texas, you committed the first degree felony of burglary of a habitation. Do you understand what you're charged with here?
Yes.
And there is an agreement that's been reached, and this states in the indictment burglary of a habitation with the intent to commit the felony offense of aggravated assault with a deadly weapon. An agreement has been reached that the defendant would be pleading guilty to the lesser included Class A misdemeanor of assault.
Yes, sir.
A person commits an offense of assault if the person intentionally, knowingly, or recklessly causes a bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another that the person knows or should reasonably believe that other person receiving the contact would regard it as offensive or provocative. An offense is a Class A misdemeanor, except it is a felony of the third degree if other portions of elements of the crime are committed in addition. So here, everyone agrees that her actions in this lesser included Class A misdemeanor fit either subpart A, 1, 2, or 3 of section 22.01 of the Texas Penal Code, assault, Class A misdemeanor. Correct.
Yes, Your Honor.
All right. So you're looking at up to 1 year in the county jail and or a fine of up to $4,000 can be assessed. Do you understand the punishment range, ma'am? Yes?
Yes.
Okay, an agreement's been reached where you would be pleading guilty here and placed on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You do well, and this case will be dismissed. If you fail, your probation could be revoked, and you could then be found guilty by the court and sentenced up to 1 year in the county jail. Do you understand?
Yes.
How do you plead to this, guilty or not guilty to this Class A misdemeanor?
Yes.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty of this Class A misdemeanor of assault?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, is submitted. Among other things, this states you mentally competent to enter your guilty plea, which is being done freely and voluntarily. You know what you've been charged with. The indictment's been read to you, buddy. You were guilty of the crime charged in any lesser included offenses, such as this Class A misdemeanor. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, Mr. Adams. All of this is true, so help you God. State's Exhibit 1.
No
Or the
objection.
referee, without objection, admitted. Pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement. If nothing further, I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow the terms and conditions of probation. The probation officer is going to go over with you, which is normal and customary for this type of offense. Make sure you understand it, follow it, and at the conclusion, do well. The case is dismissed.
Oh.
Okay, if you fail, we don't want to talk about it except to know that it could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. You don't want that. Anything else to add?
That's it.
All right, then see the probation office. Good luck. Thank you.
Thank you. Thank you.
Thanks, Langston. See you, bro.
All right. All right. Thank you, Judge.
In the end, this courtroom delivers a calculated outcome. A felony charge reduced, guilt deferred, and probation standing between dismissal and jail. The judge makes it clear, this is not forgiveness, it's conditional mercy. One violation, and the full weight of sentencing comes crashing down. Cases like this show how discretion, legal experience, and timing can completely reshape a defendant's future. If you found this courtroom breakdown as intense as we did, hit that like button, share your thoughts in the comments, and subscribe for more real, unfiltered courtroom moments where every word can change a life.